And welcome to the Week 13, Chapter 13 video lecture. We're going to talk about trials and juries. This is a very important aspect of the criminal justice system. The trial by jury is something that has been historically guaranteed to people generally, even before we had constitutions, even in very old England. And so it becomes an important aspect of what we believe is the fairness of the system itself when we have a trial. Although if both parties in a criminal trial agree to a judge hearing the case, they can have that happen. But the defendant has the right to a jury, and also the prosecution has the same right to a jury. So we can see that it is an important right, and one that again brings in this idea of fairness and justice to the system. So let's look at what kind of learning objectives we're going to have for this chapter. First, we're going to trace the history of trials by jury so we can see how they've evolved over time and where they are now. And then we're going to analyze the scope of the right to a trial by jury in a criminal case. We'll see that it is not quite what you might have thought. It is not necessarily a trial by 12 in states anyway, and not necessarily a unanimous verdict, as we'll see. All right, we're also going to evaluate the impact of differences in jury size and unanimity requirements, because in fact, in the state courts, they are not required to have jury sizes of more than 6, and they can have essentially what would be the same as a, let's see, if it's 6, then we're dealing with something like a 4-2 verdict would allow a conviction. Then we're also going to explain how a jury is summoned and selected, including the constitutional limitations on these processes. We'll see that this is a very important aspect of the jury system. It has to be a cross-section of the community, but it also has to be a cross-section of the community in terms of citizens, people who can hear and view evidence. So people who are blind that can't hear at all probably can't be jurors. People who are not citizens can't be jurors. But otherwise, it'll be a cross-section of the community that have the requirements to be a juror. We're going to discuss the function of jury consultants in the process of scientific jury selection. We'll see that becomes very important in the very big trials. The jurors are very, very important to the process, as you might know, for both sides. And so they will use these consultants who can do some scientific analysis of the backgrounds of the people involved and make decisions on whether they would be good or bad jurors in the case for the side that's employing the consultant. We're going to also distinguish between the presumptions that apply at the start of trials and the burdens of proof applicable to overcome them. And we will see that, of course, the presumption is of innocence. And we will see that burdens of proof sometimes can change over time, and also as to what it is that we're talking about. Certain defenses, for instance, there's a burden of proof on the part of the defendant, not of the prosecution. But the prosecution, of course, has the burden to prove beyond a reasonable doubt all of the charges in the case. We're also going to summarize the basic rules of evidence concerning trustworthiness and relevance of evidence so that we can see that not all evidence that we might see used in, let's say, a search warrant affidavit that's based on this just general concept of reliability in a common sense way is the kind of evidence we're going to allow into a trial. There are rules of evidence that have been honed over the past, I guess 1,000 years of jurisprudence in both English and American systems, and they have seen where some evidence is just not very reliable, so unreliable that they will not allow it to be brought into the case at all. And then for others that is sort of marginally relevant or reliable, they might allow it in certain circumstances only, where it becomes somewhat more valuable and may actually be a little bit more reliable. And we'll see these rules are very important to the process itself. If your evidence does not meet one of the rules that allows it into evidence, it will not come into evidence. Especially if it's excluded by a specific rule, it will be excluded, unless there's a very good reason why not. Also, we're going to analyze how special limitations on expert witnesses affect the litigation in criminal cases, especially with regard to leading types of forensic evidence. We're going to get into the whole topic of forensic evidence and some of the limitations on it and how the expert witnesses will affect this process. And we'll see that it is often a battle of experts, especially on the issue of insanity. That's been a leading area where expert witnesses have been brought on both sides, and it's basically hired guns on both sides, and then the jury has to make up their mind when they see what they see. We're also going to identify the steps in a criminal trial, so you can see how we go through the steps. They are all the same. They're all the same, by the way, for a civil or criminal trial. There's really no difference, unless the civil trial does not involve a jury. But if it involves a jury, they will be essentially the same steps. It is a trial by jury, and we've honed it down to certain very specific steps, and we'll go through those. We'll also describe the effects and implications of pretrial publicity and the solutions that courts use to prevent those effects from influencing a criminal trial. As you might suspect, when there's a lot of pretrial publicity, the real fear is that we may not be able to get a panel of disinterested, objective jurors because they have already heard a bunch of stuff going on out there in the world that may have also, if not consciously, then unconsciously made them think a certain way about the case. You can't have an unbiased juror when you have this kind of publicity out there. That's just the way it is. And so we'll see what that is when we get into it. Let's look at the history of trial by jury. First were the English roots. The Magna Carta required jury trials at least for the noble people. That was 1215 in England. This is where the king essentially was forced by the nobles to essentially have what was the first kind of more or less a constitution where certain rights could not be infringed on the noble class by the king. And they had rights. One of the rights was to have a right to a jury trial. What was happening is if they were tried by the king, of course it was a kangaroo court. Whatever the king wanted in terms of result was given. But that's the way it was before the Magna Carta. If there was a charge against you, you went before the king, and he decided entirely at his sole discretion, without right of appeal, what the decision was going to be. That was no longer true after the Magna Carta. In our colonial developments, the idea of a jury trial in criminal matters was transferred to the colonies because they, of course, were English for quite a while until they became American. And we did not really change the system at all, really, except to add a constitution. So we had a written constitution, something that was not available or not brought into England, other than through the Magna Carta, which is sort of a mini constitution. We have Article 3, Section 2. This required that all criminal trials be by jury, and in the state where the crime allegedly take place. Okay, that's the first of the constitutional rights regarding juries. Sixth Amendment, of course, is the right to a speedy and public trial. It also involves the right to counsel. And the Seventh Amendment. And of course, the Seventh Amendment only involves civil trials, but also allows the right to a jury in a civil trial. Now, what this means is that we can see that probably going on in the colonial times was the king essentially picking the judges that would do his bidding and keep things the way he wanted them kept. And those who were sort of bucking the trend would be on the wrong side of the judge and on the wrong side of a criminal case, which could have been trumped up, and you were basically put away in prison or maybe hung, since all felonies at that time were a hanging offense, just based on a so-called hanging judge that was in the pocket of the king. And so there was a great distrust of judges. And you can see it written in the Constitution. So there's a right to a jury trial in both criminal and civil cases, just for that reason. All right, let's look at the law in the books, the Constitution and the trial by jury. Duncan versus Louisiana. Let's look at the scope of the right to a trial by a jury. Not all persons accused of violating the law have a right to a trial by jury. First, juvenile offenders, that's a bench trial. That means a trial before a judge. And adults charged with petty offenses, something with less than 6 months possible jail time, are not entitled to a jury trial under the federal Constitution. Some state constitutions, though, guarantee a right to jury trial to anyone facing any criminal trials other than infractions, for instance. And in California, by the way, we used to have jury trials for infractions, but they did away with that recently, or more recently. And now, if you're charged with any misdemeanor or felony, you have a right to a jury trial. It's not true federally. It's not required under the federal Constitution either. So we could change our Constitution to be consistent with the federal Constitution in California and have the same rule. Let's look at Snyder versus Louisiana. Now, essentially what this is, what you want to think about here is when we are picking a jury, what becomes very important is we do not want to have people of certain groups systematically excluded from the jury in a case. For instance, you may have a black defendant. If you're a prosecutor, you think, well, if I have black people on my jury, maybe they'll be more biased towards the black person and biased against me, in my case. Well, you think, well, I should kick off all black people. The answer is no, you can't. We've made it very clear, the Supreme Court made it very, very clear. In Snyder and a few other cases, Batson was another one, where you simply cannot kick people off based on race, no matter what. They're what we call a cognizable group, one of several. Race is one, gender is another, and also it turns out sexual orientation is another. It turns out that you may be in a rape case, for instance. You have a woman victim, a male perpetrator. You may want to have all women on your jury as a prosecutor. Well, you can't do that. You cannot do that. So if you kick off men off the jury, you better have a gender neutral reason, and a good gender neutral reason for doing so, because the judge will be questioning you as to why you're kicking off men, especially if every one of your choices as a prosecutor is men, are men. Because if that's the case, the judge is at some point along the line is going to say, I don't care, you're making up reasons, I don't believe you. We are going to disband this jury panel and pick another one. And I will not let you do that again. And it may be fine the prosecutor for even having done that. It's a very sensitive area. You do not want to kick off anybody in a cognizable group ever for the reason that they're a member of that group. There better be a very good reason otherwise. Okay, if you have a good reason, that's fine, because you're kicking them off for that reason, not because of their membership in that group. So that's the big item that I want you to know about this issue, is that we do not allow this sort of discrimination against certain people on juries based on the fact that we think that they might be biased against our case. Too bad. If they are biased and you can bring that out, then you can challenge them for cause and kick them off for that reason. Any juror can be kicked off for cause. That means that because they are in fact biased, or they believe they're biased, or they say they're biased. But it's it's the peremptory challenges there where we don't have to have a reason that this becomes a real issue. Okay, so just know that for our purposes right now, cognizable groups are race, gender, and sexual orientation. All right. So if you know that, you know enough about what can be done, cannot be done with peremptory challenges by either side. And by the way, it's not just the prosecution that has this rule against it. It's also the defense. The defense can't pick all men on a rape case, okay, or make sure that there's only men on the jury. Okay. All right. Let's look at jury size. Now, the size was fixed at 12 by historical accident, supposedly, but in reality, it was actually a mystical number that was chosen probably for that reason, but it is not required by the Constitution, not the federal Constitution anyway. And so a 6-person jury is acceptable in non-capital cases in the federal world. That may not be true under state constitutions where they may require 12. But people of less than 6 have been struck down, so you have to have at least 6. And evidence has suggested there are a few differences in the deliberations between 12 or 6. My position would always be it should be easier to win a case with 6 than 12. And the reason for this is that you just simply up the chances that there's going to be one holdout in the jury with more people, and less chance with fewer people. Let's look at state provisions on the size of juries. Let's see. 12-member juries are in several states as well as California. As you can see here, these are required by their own constitution, not required by the federal constitution. 12-member juries required in misdemeanor cases. Again, California is one of those, just like every other state that's listed here. Juries of fewer than 12 authorized for select felony cases in Arizona, Connecticut, Florida, Indiana, Louisiana, and Utah. And juries fewer than 12 authorized for select misdemeanors in all these different states. So you can see it's a bit of a mix and match. Federally, again, they don't have to have 12, and they don't have to have 12 in the states unless their own state constitution requires it. Now let's look at unanimity of the jury's decision. All verdicts must be unanimous unless specified to the contrary in these notes. Essentially, in Delaware, District of Columbia, Hawaii, New Jersey, and Pennsylvania, the parties may stipulate to a jury that can consist of fewer than 12. In Arizona, 12-person jury is required if it's a sentence of death or more than 30 years imprisonment is sought. Otherwise, all felonies use 8-person juries. Interesting. California, it's 12-person no matter what kind of jury you have. Now, unanimous verdicts are not required under the federal system. 9-3 and 10-2 verdicts have been found to be good in state criminal prosecutions. That does away with this factor of, the holdouts that we see. Some people just will not go one way or another, and they're against, the very large majority of people in the jury. Connecticut has a 12-person juries that are used in death penalty cases unless the defendant elects for use a smaller one. Florida, 12 persons, but verdicts need not be unanimous. A 7-5 vote is sufficient for a death sentence. That's very unusual, by the way, throughout the states. All other felonies use 6-person juries and unanimous verdicts. Okay, so they say if it's 6 persons, it's going to be unanimous. Even in death penalty cases, they do not have to be unanimous. So 7-5 in a 12-person jury. Wow, fantastic. That's amazing. Indiana, 12-person juries are required for serious felonies or when an enhanced penalty is sought. 6-person juries are used for less serious felonies. Okay. Louisiana has 12-person juries in death cases. 6-person juries when confinement is at hard labor is possible, but not necessary. Utah, 12-person juries must be in capital cases. 8-member juries in all other felonies. Oregon, permissible by 11 of 12 jurors voting for a guilty verdict. In Puerto Rico, conviction is permissible by a 9-3 verdict. Unanimity was required since the 14th century, but in the 1970s, the Supreme Court held that federal criminal trials must be unanimous, but state verdicts of 9-3 and 10-2 have been upheld. Research shows unanimous juries tend to be hung less often, deliberate less thoroughly, and result in more satisfied jurors, which is interesting. But it means that you get to a verdict, because one thing that juries don't like is spending a lot of time working very, very hard, going back and forth, and then not get to a verdict. All right, master jury lists. What happens is we typically use voter registration lists. Why? Because if you're using with the voter registration list, you're dealing only with citizens. Citizenship is required to be on a jury. We don't believe that people who are non-citizens will have the requisite interest in the system to be jurors, and so that reason that it is required. The advantages of the voter registration is it's readily available, frequently updated, and collected in districts within judicial boundaries, so that you can get a very nice cross section, which is required. You can't say, if a county is your jurisdictional boundary, you got to have a cross section from the county. Disadvantages is it excludes the poor because they don't always register, the young who don't always register, minorities who don't always register, and the less educated who again also do not register. So they will be systematically excluded, but only because they don't sign up in the voter registration. So in California, we also look at the driver's license records to augment this, because most people have a driver's license. You can certainly use telephone directories and utility company lists, but then they don't necessarily have only citizens. People who are legal residents can also have listings there. Same for driver's licenses as well. Most states allow legal residents to have driver's licenses. All right, jury panels can be challenged if they fail to include racial or other minorities. I had a case where it was against it was a major drug case against all Hispanic and Mexican nationals, and it turned out of a panel of 120, we had 3 Hispanics, and in our community in California, we would expect it to get a lot more. We had to bring in the actual juror commissioner, who was able to show, statistically speaking, that even though there may be approximately a third of the population who are Hispanic in our area, only a much smaller percentage are actually citizens. And of that, this 3 out of 120 is statistically within a range of what would be pulled randomly from the population of citizens. So it turned out that the panel was allowed to be used based on that evidence. But it was a good example of how the fact is that you can challenge a panel for not being a representative sample or excluding a cognizable group because of the way it was chosen. There's a requirement of representative cross-section of the community that applies to jury pools, not to juries chosen from the pools. So again, you may have the proper representative numbers of racial minorities, but you may not have that on the actual jury that is chosen, depending upon how things go and what happens. So it's not a matter of the makeup of the jury has to be a certain racial makeup. But you have to pick from a cross section of the community, which will include the racial minorities as well as majority people, and so you want it to be representative of that community. Otherwise, it's not going to work. And if it happens to systematically, even unintentionally, exclude a cognizable group, it's also objectionable. All right, summoning the venire, which the venire simply means the jury panel. Jury panel is the people we bring in. So if we have a jury where we're going to have 5 alternates, and it's going to take a very, very long time to try the case, we could easily bring in 100 people. There will only be 17 people on the juries, 12 actual jurors and 5 alternates. But there are a lot of people who will be giving excuses because they can't have a trial that long without going into bankruptcy, and they're released from jury service on that case, and they'll come in on a shorter case. But you can easily have 100 people brought in of our venire, which is the panel itself. It's again random selection from the master list. Not all persons chosen will serve on the venire. Most states have certain requirements for that venire, and so again, you have to also, once you've got a very large group of people you've brought in, that's a random selection from the community, you have to randomly select from that group to get the venire or the jury panel for a particular case. That just makes it fair. It's just random, rather than people. Oh, I like this person. We're going to pick that person to go on this panel. That kind of thing. Statutory exemptions may exclude others. Like for instance, if you can't hear or you can't see, you probably can't be a juror. If you cannot speak the English language, you're not going to be a juror. And there are some citizens who really can't, and so they are excluded. Random selection from the venire itself. So what happens is you have a venire, that's your panel, comes into the court. Usually they sit in the audience. And then from that already randomly selected venire, we randomly select people to come up and be subjected to voir dire, which is the process of interviewing them to see if they can be fair from the venire. So it's random. And summonses, we actually have to summon people in. They don't have a choice. They have to come in. And they can be prosecuted criminally, by the way, if they don't come in. All right, categories and frequency of statutory exemptions from jury service. Previous jury service in 47 states is good enough. Age is good in 27 states, 65 to 75, which, by the way, is probably not a good idea because that is an age group where you'll get most people who won't try to get out of jury service because of financial reasons. They typically have retired by then. Political office holder in 16 states are excluded. Law enforcement and emergency service personnel in 12 states. I don't know why. except they think they're probably biased. I don't think that's true, but it does happen. I've led on people, as a prosecutor, I've led on people in the public defender's office routinely without any problem whatsoever. Usually it's clergy or teachers or in 12 states. I don't know why that would be true either. It doesn't really make a lot of sense. Judicial officers in 9 states. So if you were a judge or a magistrate, you cannot serve as a juror. And healthcare professionals in 7 states. The only reason why I could think of for healthcare professionals would be that they may be experts in certain areas, and they would be afraid that they would just bring in their own expertise over that of the experts that are brought in for deciding the case. All right. Also, sole caregivers of young children or incompetent adults in 7 cases. Licensed attorney in 6 cases, which is interesting. I don't know why. Although I've always had a problem being chosen on a jury, not because I was an attorney, but of course because I was a prosecutor. And I don't know why that's true either. I can be perfectly fair, but there you go. Active military in 5 states. That might make some sense because it would be difficult to know when they're going to be pulled out. They could be pulled out in the middle of a trial, that kind of thing. And it's very difficult for them to serve when they've got orders to do things and that sort of stuff. Okay. The voir dire. Now that means to speak the truth in Latin, and it's the process by which we take the people who have been put in the panel itself, not the panel, put in the jury box as the 12 people who might end up being jurors, where we subject them all to voir dire or in an interview process where we can ask them questions to see if they are biased or whether they can be fair. It's a preliminary examination of a prospective juror, and it allows us to challenge for cause. And what that is if someone says, you know what, this is a DUI case with an injury, I was in a DUI case as a victim, and I was badly injured. It has ruined my life. I really can't be fair. If they say that, then we can challenge them for cause. That means there's nothing wrong with them. That's the experience they've been through. But they're not good for this kind of case. They would be perfectly good on another kind of case, but not on this case because they've got some thing that went on in their life that means that they really can't be fair in this case. They're going to convict the person no matter what. Why? Because they don't like people who drive with alcohol. That's what caused them to have their life ruined. Okay. Now, peremptory challenges. Again, peremptory challenges are the ones we can challenge a certain number, and every state has a different number. Typically in a felony case in California, each side gets 10 peremptory challenges. You cannot use that peremptory challenge to kick off people in a cognizable group, which includes race, gender, and sexual preference. And you cannot kick them off for that reason. You have to have a justifiable reason outside of their group membership in a cognizable group. Okay, here's the cases that have brought this out, and they are very, very clear. Now, serving on a jury, we typically have alternate jurors. They're serving even if they are not on the actual jury, or not in the actual jury box of 12. They will have to listen to the case just like they were regular jurors. And in the event that one of the regular jurors has to be excused in the middle of the process, they will pick up and go into the group of 12 and serve as a juror. Regular jurors may be excused through the process, and that's why we have the alternates. Overall satisfaction for serving on the jury usually is very high, especially if they get to a verdict. There's a focus on reducing inconvenience of jury duty. They make it as easy as they possibly can on people. They really do. They understand most of them get paid enough to buy them lunch, and that's about it, and not even enough mileage to pay the cost of getting to and from court. And so it's a community service, but it is also required. It's a service of being a citizen. 1/3 of Americans will serve on a jury, as it turns out, and many of you probably have as well. Let's look at People versus Garcia. This is a case that was charged with burglary. There was a Batson type argument. Batson type argument is one, of course, where the defense or the prosecution says the other side kicked off jurors for being in a cognizable group. In this case, it was The cognizable group was claimed to be homosexuals. It was 2 lesbians that were kicked off. Back then, it was not yet recognized that homosexuals was a cognizable group. It went up to the Court of Appeal after the trial court found that the peremptory challenges were good, and the appellate court reversed and said no, homosexuals are a cognizable group. So the first time we've actually seen it where there was a holding that homosexuals are a cognizable group. You cannot kick off people off a jury because they're homosexual. End of story. So in essence, they think that they are a group that has a very specific perspective based on their experience of being persecuted for so many years, and they are someone who should not be excluded for that reason. All right, law and action. Let's choosing a jury biased in your favor. How do you actually do that? Well, first you pick alternates that will hopefully be good. You pick both jurors and alternates that you think are at least not biased against you, and then you start educating jurors that are actually in the box, and you do that through your voir dire process. You bring up essentially some of the issues that are going to come up, and you make them think about whether they can be fair, and you ask them pointed questions, but in a very nice way, and ask them for their best truthful answers, and you get them if you're nice to them, and you are perceived as being someone who's interested in finding the truth in the case, you're likely to find that they start being biased in your favor. That's just a normal process. We can also think about feeling the case in terms of if we don't have any information on the jurors other than what little they give us about where they live and how many people there are in their family and that sort of thing, where they work, what kind of professions they've been in. Then we can use a feel, so to speak, and an emotional response. And that usually comes because we've interviewed them and we get a response. Sometimes you'll get a response from someone, you can kind of tell they don't like you. If you find somebody like that, you probably want to knock them off. And that's a good enough reason to knock them off. You can say, hey, Judge, I didn't knock this person off because they were black. I kicked them off because when I talked to them, they were very short with me, and I could just tell from looking at the body language this person does not like me. And so I kicked them off because I think they'd be biased against my case because they don't like me. Or maybe they don't like my case. I don't know what it is, but whatever it is, I don't like it. That's good enough. Okay. Now, scientific jury selection has come up more recently. There are psychologists and sociologists who have studied what certain backgrounds of people will do in terms of how they are likely to vote as a juror. And they get pretty good at it. And so they can, through the reason why this works, by the way, is that only in very, very large cases, one with big, penalties like murder cases, the jury will actually be asked to fill out questionnaires, and they're very detailed. They could be 20 pages long of a series of questions, and they have to fill all those out. Now we get all that information, and then we give it to the psychologists and sociologists, and we ask them, who are good people for us on our case, and they will go back and they will profile them based on their backgrounds, and they'll tell you which ones are definitely ones you do not want to have on your jury. They will tell you which ones you definitely want to have on your jury, and they'll have some that are in between. So we use those questions to uncover hidden biases. This is all based on their personal experiences in life, based on who they are, what they've been through in their lives, and so on. And so you develop a profile on each and every juror that's in the entire panel before it's even brought up to the jury to be selected to put in the box to see if they may become jurors. Consultants are hired mostly by defense attorneys, and so what will happen is they'll deselect jurors that are not favorable to the defendant. They'll basically kick them out on peremptory challenges if they can't get them out for cause. All right. Now again, they have good reasons. Then they can even kick people off who are in cognizable groups. Some of the starting presumptions. Let's look at presumptions and burden of proof. Presumptions have to do with we presume certain things, and then what that means is that someone has the burden of approving the opposite. So when there's a presumption, there's a burden of proof that someone must prove the opposite. We will essentially, for all intents and purposes, believe something is true unless somebody proves to the contrary. And that's the person with the burden of proof. The starting presumptions, of course, all defendants are presumed sane unless evidence of insanity exists. That's the first presumption. That means that the prosecution does not have to prove that the person who they're prosecuting is sane. That means that there is a burden of proof on the part of the defense to bring up evidence of insanity in order to be able to put that into issue. Okay, so they're presumed to be sane, so that the prosecution doesn't have to prove sanity. Also, of course, presumption of innocence. Defendant is not required to prove that they are innocent. It is the duty of the prosecutor to prove that he is guilty. So presumption is that they are innocent, and the contrary must be proved by the prosecution beyond a reasonable doubt. So burden of proof has to do with the burden of producing evidence. It also has to do with the burden of persuasion. So you first have to produce evidence. You can't just say something is true and make it happen. You have to produce evidence that tends to negate the presumption. And then you have the burden of persuading people that that presumption is now overcome. And then you have to do so at the standard of the law that's what's required. And of course, for the prosecution, that's reasonable doubt. Sometimes on these defenses, sometimes it's only a preponderance of the evidence that has to be proved by the defense on certain types of defenses. But otherwise, every time for the prosecutor, it's the burden of proof is beyond a reasonable doubt. Let's look at types of evidence, because this is very important. There's all sorts of different evidence you can bring in. I've never been more surprised sometimes by the kind of evidence that comes into trials. It's just amazing sometimes. First, though, there's two categories of evidence. One's direct evidence, one's circumstantial evidence. Direct evidence is typically eyewitness evidence, but it's evidence that by itself would prove the crime. There's no inference necessary. Usually it's eyewitnesses, because you need someone to say, yes, I was at the scene of this murder. I saw John Jones take out a gun and shoot Jane Jones, his wife, and she died. Okay, that's an eyewitness. That's direct evidence. There's no inference necessary. A jury could find that John Jones murdered his wife on that eyewitness testimony alone. There would be no inference necessary from that, or to draw from that. Circumstantial evidence, on the other hand, is what we call indirect evidence. It means that it's evidence that, when put together with other evidence, raises a inference that something else is true. So, for instance, we may have all sorts of circumstantial evidence to say, first of all, that a crime has taken place. We have a dead body. The dead body has 3 bullet holes in the back of the head. Probably that's pretty good evidence. We can draw the reasonable inference that this person was intentionally killed by somebody. We might have indirect evidence as to who that was, because maybe there are no eyewitnesses to it happening. We can see that the gun that was used in the killing was owned by the defendant. The gun was in the possession of the defendant when he was arrested 3 hours after the shooting. There was gunshot residue on the defendant's hands when he was arrested. Lots of other pieces of evidence to suggest he's the one that shot this person and killed him. That's indirect evidence, because it all requires us to add evidence together to come up with a reasonable inference from all that evidence as to what happened. Okay. Now, there's a lot of people who say, you can't prove a circumstantial evidence case, or they're weak and so on. There is no difference between direct evidence and circumstantial evidence as to its convincing force necessarily. It is all up to the jury. Sometimes eyewitnesses can be completely wrong. They picked out the wrong guy. And you think that's the best evidence out there. Well, not necessarily. Circumstantial evidence, especially if it comes from many different sources, all pointing towards the defendant being the person who did the crime, is probably very good evidence and very strong evidence. And so it's not whether it's direct evidence or circumstantial evidence. It is the convincing force of the evidence that makes the difference. Let's look at types of evidence. First, there's testimony. These are people of competent witnesses who come in and testify as to what they heard and what they saw. There's real evidence, which are objects of any kind of physical objects of any kind. It would be the gun, the murder gun, the some residue of one sort or another from the scene. Some of the we may comb the carpet in a certain area and bring up a bunch of evidence of threads that were there, tiny little threads that were consistent with what the defendant was wearing that day. So it looks like he may have been there at that time. Also, in essence, if it's physical and it's an object of any kind, it's real evidence. Then we have scientific evidence, which is basically a forensic investigation of the evidence in the case. And they then put together, from a scientific point of view, more evidence. Essentially, they may be able to put together the fact that we see 3 bullet holes in the back of someone's head. We take out one of the bullets from the person's head. We examine it through forensic analysis, and then we compare that to a bullet that's been shot from the defendant's gun, and we find they are one and the same in terms of the patterns of scratches that are on them that are very distinctive of a particular gun. And they'll say that's essentially a fingerprint that tells me that the bullets in the back of the head of this person were shot by the defendant's gun and no other gun. So what's happened is, through a forensic investigation, now we have more evidence in the case than we had before. There's also demonstrative evidence. This has no actual evidentiary value by itself. It would be an example would be a dummy that we use that has bullet holes in it where they entered and where it exited the body, and then there's a rod put through the dummy showing the angle of the bullet's trajectory into the body. That would just be a way of demonstrating to the jury why, for instance, we say that the defendant's statement is a lie. It could not possibly have shot from that angle based on his story. He's lying. If he's lying, that means he's covering up what he actually did, and that's good evidence. So the demonstrative evidence simply demonstrates what the other evidence has said. Now, charts are also another one. Compilations of information are demonstrative evidence. They're all derived from evidence that's already in the case, but they're not evidence by themselves. All right, so let's look at some of the basic rules of evidence. Trustworthiness is the key to all these rules of evidence. We don't allow in evidence that's not trustworthy enough. We have several rules. There's only a couple of them here. The best evidence rule is one of them. The best evidence rule, by the way, has pretty much been put away. It's no longer as important. What it requires is that if you have a document, such as a contract or a letter, you have to bring in the original document, not a copy, unless you can prove that the original no longer exists, and you can explain why a copy needs to be brought in. That has since been done away with in most states. In essence, it's no longer required in most states. But it used to be a rule. You had to bring in the original document. You couldn't bring in a copy. Again, not so big now. Hearsay is another. That's a big one. Hearsay is a big one. Hearsay is someone saying something about the case outside of court. And we don't even necessarily know who the person is. Let me give you an example. You were at the scene of an automobile crash, and someone says, "Boy, did you see that car? He was driving 60 miles an hour in a residential zone, and then he slammed into this car." Okay, well, that's someone saying something about the case. Okay, let's assume that people heard that statement, but no one could, since there's a large crowd of people, no one knew exactly who it was who said it. If you try to bring that statement into court, boy, you wonder if you don't even know who said it, and maybe the other people weren't even looking at the accident. This is the only person who saw the accident, apparently. Maybe that's not good enough, because we don't know, that person wasn't brought in to testify. We don't even know who they are. They could have just been making it up. We don't even know. We have no idea, and so that probably will not be admissible. Now, there can be exceptions to that rule. In fact, actually, the hearsay rule has more exceptions than you can imagine, and essentially they eat up most of the rule. So the only thing that's really excluded in the hearsay rule are the classic hearsay of someone saying something about the case, and there's absolutely no way to know whether it's truthful or not. and that person is not in the trial being examined on the stand, and there's no way to know. Okay, that's because you could say anything you want out there in the world, and we have no idea. We can't even just determine whether it's truthful or not if we don't have you there testifying as to what you had to say. There's no way. So that's not trustworthy. Also, there's a relevance requirement. You can't just bring on any old evidence. If it's not relevant to the actual decisions to be made in the case, it's irrelevant. It can also be misleading. A lot of times people, defense attorneys or prosecutors like to slime the other side by bringing in a whole bunch of stuff that has nothing to do with the trial or the issues involved in it, but it's just there to make the defendant look bad, or to make the prosecution look bad, or to make the police look bad. It's generally going to be excluded because it's not relevant to the case, and it's misleading to the jury. So again, you must have a valid reason for inducing the statement, object, or testimony, in that it must tend to prove some issue that's in the action itself. Scientific evidence. The big issue regarding scientific evidence which is where we have scientific experts, like your fingerprint expert, like your ballistics expert, like your accident reconstruction expert. These people who have a science that has been used and found to have reliable results. The biggest issue with regard to getting that kind of evidence on is first to determine the reliability of the scientific evidence. There is a case of Fry that brought up the first test to decide whether scientific evidence is sufficiently reliable to be brought in. That was the Fry case, and it said that the evidence has to be generally accepted in the scientific community as reliable in finding the truth. It has to be generally accepted. There always is room for certain people in the science that say, well, this isn't very good, but it has to be generally accepted. If it's not generally accepted, it does not come on. And then there was the Daubert case where it has to be both relevant and reliable. And so what that means is that your scientific evidence has to be capable of giving us some additional insights into this case and the issues in the case, not something else. Okay? And so that's the standards for the scientific evidence. And we had problems with DNA at first, by the way. And not only with DNA itself, but we also had problems with the multiplying rule, which is essentially a way of saying, okay, what are the chances that anybody else in the world has the same DNA? Well, what they used to do is take each piece of the DNA, which there's thousands and thousands. Well, not thousands. If you're looking at the part that's distinctive of a particular person, maybe a couple hundred items in the list of the code that they use in DNA. But if you multiply one times the next, times the next, times the next, times the next, it can be to astronomical, into the billions and trillions of people. So essentially what that means is that it would maybe 1 in 100 trillion chance that someone else shares the same DNA. And so that makes it almost impossible for us to believe that the DNA came from anyone else except the person who is found to have that DNA. Okay, and that's why DNA is so good, is that unless you're an identical twin, your DNA will be different. Just like very, very similar to fingerprints, we think. But that doesn't necessarily mean that it's perfect for every case, by the way. So don't think DNA is the magic answer for all cases. It will do nothing for you in a fraud case, for instance. But it does do a lot in cases where there is DNA around, if we're trying to figure out who was where and what they were doing. Okay. All right, look at forensic science evidence in the age of Daubert. There's blood expert, of course. If we find blood on the scene, we can identify whose blood it was, often to very high levels if we can get the DNA out of the blood. And if not, we can get the type of blood, and that can be typed to a certain person. Type is not as good because many people have the same type of blood. Not everyone has the same DNA. Firearms, of course, many different aspects of firearms. To identifying what firearm shot a specific bullet, to fingerprints on the firearms, which is the second category, fingerprints. Those are big, as you might imagine. We're actually seeing that we can find fingerprints where people were wearing rubber gloves because of super glue. Super glue, we simply super glue an item and the fingerprint will show up because the rubber gloves are not good enough to keep that little pattern from hitting the surface of a nice glazed surface. You can't see it with your eye, but if you put super glue on there, the super glue will adhere to the pattern and you'll see the fingerprint. There's also junk science. This is science that has not been generally accepted. Someone is doing studies on things and they think they found something, but the scientific community has not yet recognized it as real science. And those are things that you will not allow, they will not allow on. It's not sufficiently reliable. Pseudoscience contributes to wrongful conviction. Pseudoscience is, some people thinking that, I'll give you one example. There was a clock tower incident in Texas where there was a mass murder going on. A guy just took a big rifle and started shooting people. This is back in the 1950s. They ended up shooting him and killing him. And they examined his brain, and they found a tumor in his brain, a certain type of tumor. And so now there's a pseudoscience that says if we can see any abnormalities in somebody's brain, we can think that's what caused this person to kill somebody, not their own will, for instance, so that they are essentially they were insane at the time that they did their crime. And that has both, when it's used on either side, it'll result in wrongful verdicts, whether it's conviction or otherwise. There's new debates on the validity of forensic DNA analysis, and it used to be on the issue of the multiplication rule. That has since been pretty much decided as we can use that rule because that's just all the evidence is showing that that's probably true. We've yet to find anybody with the same DNA who was not an identical twin. Then there's a CSI effect, which is a real problem, and that is that jurors are coming to expect forensic science evidence in every case, even if that forensic science evidence may not be of any value, but they're expecting it. And that's because they see it all the time on TV, and they get upset when they don't see it. It usually works against the prosecution because they expect the prosecution to prove its case and wonders why there's no forensic evidence in this fraud case. Well, the person admitted that the documents were theirs. We don't have to go and get fingerprints on the documents to figure that that's their documents. They admitted that there was their documents. And there's no doubt about the facts of what was collected in the evidence. It's all good, reliable evidence, and it all was confessed to in terms of whether it was theirs or not. So why would we need a forensic person to tell us anything about it? You just don't. And so we get into this problem. It's just a juror's expectation, and it's brought problems into the system because there are some verdicts that go with not guilty that should not have because they say, where was your forensic evidence? And of course, when you ask them, what forensic evidence would you like to have seen, they can't tell you. All they can tell you is they saw it on TV that everything has forensic evidence, and that's not necessarily true. All right, court's controversy in the administration of justice. Should fingerprint evidence be admissible? Well, where do you stand on the admission of fingerprints evidence? Well, one of the reasons that fingerprint evidence is an issue is the fact that there has always been a presumption that every person in the world has a different fingerprint. It just happens to be that no one has ever been able to prove that two people had the same fingerprint. It's never happened, and we've been using them for over 100 years. So probably it's probably good. The problem is when you get partial fingerprints and whether you can compare that to a specific person or not. And when you get partials, maybe it is possible two people have the same partial. We don't know. That has not come up. But there have been cases where fingerprints evidence has been found to be, the comparisons have been incorrect. But the partials were close, really close, but it was not the same person. So given the current state of scientific knowledge about fingerprint analysis, should fingerprinting analysis be permitted to testify as experts in criminal trials that the defendant's prints match those found at the crime scene? There's been a lot of controversy over this because there have been cases where we're finding that when very well-known experts, including experts that were employed by the courts, have come in and said, yes, these are a match, and turned out it was not the same person. And when they actually looked in more detail, they found that there were differences. But they still came on and testified. Every one of those experts came on and testified that, in their opinion, it was a match. And so there are some problems there. So it's not necessarily with the presumption of fingerprints being different for all people. That's the big issue. It is whether the matching of them is the same person, especially with partial prints. All right. Here's the CSI effect. Percentage of jurors who expect scientific evidence from prosecution. Depending upon the crime, it varies. In murder, of course, you expect a lot, as you might imagine. Assault, maybe less. Theft, of course, less. Breaking and entering, maybe. Rape case, we expect a lot, as you might imagine. Crime involving a gun, absolutely. And so it makes sense that we would have lower expectations in assault and breaking and entering. But by the way, breaking and entering, you often have to prove who it was who broke it, not whether there was a break-in. And that can involve quite a bit of forensic evidence, depending on the case. And so we're looking at, just any old case. We're still looking at pretty high numbers. So the CSI effect's actually been studied, and it's definitely there. Let's look at objections to admissions of evidence. First of all, what's very important is you have to have good, competent counsel, because you have to make timely objections to evidence. If you do not object before the evidence comes on, you have waived the objection. You cannot wait till later. Oh, that shouldn't have come on, Judge. Let's exclude it. No, for a lot of reasons. Number one is we have to make that rule, because otherwise the jury's going to hear it. They're going to see it. It's hard to unring a bell, so to speak. And the other is that sometimes you may want to allow on evidence that would otherwise be excluded because it fits your purpose. So we allow you to let it in by not objecting to it. But if there is proper objection and it is allowed on when it shouldn't have been, and if it makes a difference in the trial, you will end up with a mistrial, or at the appellate level at least. They'll send it back for a new trial. And also, you also have to challenge forensic evidence. If you're going to challenge it, you got to challenge it before it comes on. And so you have to know what is coming up, and that's part of the discovery process. Most people know what kind of expert's coming and what they're going to say, because they have reports that have been exchanged between the parties and so on. And then you have to make the objection before that person is allowed to testify to anything. All right, let's look at the steps in the trial process. First, there are opening statements. This is, by the way, after we have sworn in a panel of jurors. Okay, that's actually the first step. And actually, if you think about the really first steps, we bring up a panel of jurors, and we select from the panel. We do the voir dire process. We end up selecting a jury. Then we swear in the jury. That's all previous steps to all this. Then we have the opening statements. The prosecution will always make an opening statement. The defense can reserve theirs until they put on their case in chief, or they can make it right then after the opening statement of the prosecutor. Then the prosecutor will put on its case in chief. It'll put on direct examination, indirect examination, and motions for judgment of acquittal will come after that. So what we got is essentially, the prosecutor will put on its witnesses and its evidence. There will be direct examination by the prosecutor, and then the defense attorney will cross-examine these witnesses, and it'll go back and forth, by the way, between these two until there's no more questions. And then at the end of the prosecutor's case, we could have a motion for judgment of acquittal when the defense believes that the prosecutor has not proved its case, there's not sufficient evidence to prove the case, we will get a motion to acquit. That doesn't always happen, and it's very rare, but it does happen occasionally. Then the defense can put on a case in chief. They do not have to, because they do not have the burden of proof. The prosecution does. They can sit back on the prosecutor's evidence and just criticize the evidence as their own defense. They put on the defendant as a witness or not, as the case may be, because he has a right against self-incrimination. And again, there may be a renewal of a motion for acquittal after the defendant testifies or the defense case is put on in chief. Now, again, the Fifth Amendment protection against self-incrimination is true as to both the defendant and as to witnesses. You can't ask a question that's going to likely bring out evidence that could incriminate even a witness, let alone the defendant. But if the defendant gets on and testifies in the case, he's waived the Fifth Amendment protection on that case. He or she's going to have to answer all the questions. The defense attorney must consider whether the defendant's story is believable before they put their defendant on, and how competent they are to testify on very vigorous cross-examination. Then the defendants who take the stand are subject to cross-examination by the prosecutor, impeachment of their credibility by the prosecutor, and renewed motions of judgment of acquittal after they testify. But what's very important about this is very many defendants have criminal records, and sometimes felony criminal records of crimes of moral turpitude. And those can be used to affect their credibility. So essentially, by putting the defendant on, you bring on their entire rap sheet of the serious crimes that they've committed. And that will definitely have an effect on the jury, to say the least. Now, rebuttal. A rebuttal case is where, let's say the prosecution puts on its case, the defense puts on its case. Well, if the defense puts on a case, puts on any evidence whatsoever, then the prosecution has a right to rebut that case. If the prosecution rebuts that case, then the defense has a right to what's called surrebuttal. That is to rebut the prosecution's rebuttal. And it goes back and forth, by the way, until there's no more evidence to bring out. And we often will discredit testimony of witnesses and other evidence somehow in our rebuttal case. However, typically in a rebuttal case, it's discrediting the testimony of witnesses who were brought up by the opposite side. Now, closing arguments is the next stage. Prosecutor will tie up the facts, argue for the verdict of guilty. They'll organize everything together, make it real easy for the jury to understand. Defense attorney then highlights evidence favorable to the defendant, criticizes the state's witnesses, calls upon jurors to return a verdict of not guilty. Prosecutor then comes on next. So it's the prosecutor, the defense attorney, prosecutor. Prosecutor gets the last word because they have the burden of proof, and they get to essentially rebut the defense case that has been argued. Okay, so they put on their own argument, the defense puts on its argument, and the prosecutor can rebut the argument of the defense. Then there are jury instructions. These are the legal instructions on how the jury is to approach its task, what law there is that needs to be applied, what elements are of each offense. They're specific to the case and only to that case. It also gives you verdict forms that for the possible verdicts that are there. And then a charging conference, which basically means they're charged with the duty of fairly and unbiased determination of the case. They're sent into the jury room to deliberate. So next we have jury deliberations. And the question has always been asked, what motivates a jury? Jury usually vote as soon as they retire to the jury room. That's usually the case because usually the cases are pretty clear one way or another. And hung juries are somewhat rare. They do happen, and I've had them happen to me as a prosecutor. It does happen. And then, so the Allen charge is basically where the jury has been deliberating for a very long time, and they maybe not even come out to ask the judge questions or otherwise. It's just taking a very, very long time. The judge may bring them out and tell them that he or she wants the jury to continue the deliberations to see if they can possibly come to a verdict. Okay, and they will often, if the jury comes out and says, you know, we seem to be hopelessly deadlocked, the court will often ask just for what the numbers are, without saying which side is which, and then decide on whether they're going to declare a hung jury and then a mistrial or not. Now, if you had a 10-2, likely the judge is going to send them back in to deliberate some more. Are juries biased? We have seen situations where jurors have concealed bias in the voir dire process, and it comes out when they're speaking to other jurors in the deliberation. And this can be the basis for either a motion for mistrial after the verdict or on appeal for a reversal of the conviction. Okay. Post-verdict motions, assuming that we have acquittal, it ends the case, the defendant goes home. Nothing to do because jeopardy is attached. There's nothing to do. Even if the prosecution got a raw deal, there were a lot of errors made in the prosecution's introduction of evidence, whatever it may have been, too bad. They lose. It's over with. Jeopardy is attached, at least for that particular jurisdiction. If it's guilty, you can be a motion for a new trial based on something that happened that could maybe convince the judge that that a new trial is justified. Mostly a formality. Few are ever granted. It would have to be that the judge realized all of a sudden that he or she had made a big mistake, and that this case is likely to be reversed anyway, so granting a new trial. Okay. All right, law in action, trials versus balancing wheels. Popular standards of justice. The major reason for disagreement between a jury and a judge. Sometimes juries will get into a situation where they know that the defendant is guilty, but they will nullify with a verdict of not guilty anyway. They don't like, they don't think that the prosecution was a just prosecution for this person, and they will nullify. That means that they were convinced the person did what the prosecution said they did, but they're going to find them not guilty anyway. It happens. And that's just part of our process. There's nothing you can do about that. If that happens, it happens. So the jury essentially is creating legislation. They're creating, they're saying that what was in fact against the law is not really against the law because we're convinced it happened, but we're not going to find them guilty. Also, uncertainty. Plea bargaining reduces the uncertainty of lay witnesses involved in the deciding legal matters, and making sort of a mockery of the system in terms of thinking that justice is more important than the law, and saying that that they're the ones who are going to decide what the law is. That happens, by the way. So that's another thing to think about when we deal with the courtroom work group, and the 0.01% of that happening is very real. All right. Pretrial publicity. The problem with pretrial publicity is that it can likely taint a jury panel that you're going to pull in. If everybody in the whole community is basically seeing lots of pretrial publicity on a criminal case, lots of news media stuff on it, some of which is true, some of which is not, most of which is incomplete, they're going to start forming opinions about who did what. And once that happens, you probably can't get a fair jury. It's just maybe impossible. Not within the community itself. But few criminal trials involve publicity, thank goodness, because then we don't have that kind of problem. But when it does, we have to figure out what its effects are on juries. Is it been so great that we really have to admit that we're not going to be able to find a truly unbiased jury in this community? If so, then we're going to have to probably move the trial to another community where that pretrial publicity has not been heard. All right, reconciling fair trials and freedom of the press. There's often limited gag orders that prevents parties within the lawsuit, which is the prosecution and the defense, from making any statements to the press. And it can be limited or it could be absolute. No statements whatsoever, or only a limited amount of statements. And you can then change the venue. That means change from this community to another community. Take the trial off to another community, and it happens every once in a while. And you can also sequester the jury as another possible way of doing this. It prevents them from seeing any pretrial publicity or post-trial publicity and being influenced by it. Media in the courtroom. A lot of changing views on cameras in the courtroom after the O.J. Simpson case especially. People have been very down about it. They think that that was one of the reasons why people acted the way they did, including the judge, and making rulings that it did. It was based on the fact that he was on TV and being watched by the entire world. And so many places now, and most courts are taking a very hard look at this. And in federal court, you will not see any media in the courtroom except reporters, and they can draw pictures of people. They can report on what happens, but they cannot have any audio tapes or videotapes of what's going on. That has not yet been brought down to the states, so they can still make their decision on whether they do that or not. And there's lots of media distortion of what's going on in the action. We saw that in the O.J. Simpson case. Distortion can sometimes be natural because you're seeing a lot of stuff that the jury does not see, and so you're not seeing the case from the juror's point of view. And there's much misuse of that technology because it can sometimes make people look worse than they normally look. Make them look more sinister, perhaps, and that sort of thing. It can happen. Also, the angle that they are being viewed from is very important as to whether it be fair or not fair. All right, that's it for Chapter 13. And again, if you have any questions regarding the learning of this chapter, please feel free to email or call me, and I'd be more than glad to help.